Well, good morning, everybody. It's 1 minute past 11, so I think we're going to get started. Good morning and welcome to you wherever you are. We're so grateful that you are taking this opportunity to come and listen to 3PB Barristers today. My name is Emma Waldron, for those of you that don't know me. I'm a barrister at 3PB and I specialise in court of protection matters, education law and also clinical negligence. I am joined today and presenting with me is Matthew Wyard. Matthew is one of the newest additions to the team, but my what an addition he is, and he brings with him a wealth of experience, having worked 3 years previously in-house in a public law and court of protection department in a national boutique law firm where he gained substantial experience. He is 3PB's rising star in this group, and you don't have to take my word for it because he is recognised as being such in Legal 500. Matthew is so in demand that he may have to leave early today to attend to an urgent case in the Court of Protection, which seems rather fitting given what we're talking about today. So if that does happen, I know that he will apologise in advance, but we're going to hear from him first. He's going to take us through the cases of Pentrust Limited and West Berkshire District Council, and then Plk and others, and I'm going to round us off with a bit of a summary of ACC and others. So we now have this awkward moment where I'm going to try and share my screen and hope that the technology works. So bear with us for 1 minute and then I'm going to hand over to Matthew. There we go. All good so far. Matthew, over to you.
Thanks very much, Emma. I always find these introductory things rather awkward, although I do feel like I should bring you everywhere with me now. I think it would go down very well every time I step into a room. Yeah, so apologies in advance to everyone if I do disappear halfway through. There's a good chance my hearing at 12 is going to be vacated, but I haven't had a nod yet. So if I disappear, it's not because I've got bored and left, it's because I've got something better to do, only joking. So as Emma says, the first case I'm going to talk to you about is the case of Pentrust Limited and West Berkshire District Council. I've given you the reference on the first slide. This is a case that was concerned primarily, amongst other things, with the interpretation of paragraph 12 of Practice Direction 12B of the COP rules. In particular, the circumstances when deputies can seek detailed assessment of their costs of acting when P's estate has a net value of less than £16,000. Next slide, please, Emma. Now, as a reminder for everyone, this is paragraph 12 of Practice Direction 19B, the relevant one in this case, and it says that in all cases where fixed costs aren't appropriate, professionals may, if preferred, apply to the Senior Court Cost Office for a detailed assessment. This does not apply if P's net assets are below £16,000, where the option only arises if the court makes a specific order for detailed assessment in relation to an estate of a value of less than £16,000. So if P's net assets are £16,000 or above, then yes, off to the Senior Court Cost Office for a detailed assessment. If they are £16,000 or less, the default is that unless the court makes an order allowing the assessment, then you can't have that assessment. Next slide. Now, the case of Pentrust itself. So the application was brought by Pentrust Limited. Pentrust Limited, for those of you who don't know, is the trust corporation maintained by what used to be Pennington Manchers, is now Pennington Manchers Cooper law firm. I don't know if anyone from Pennington Manchers is listening today, but if you are, thanks for this case. And they had previously been appointed as the Property and Affairs Deputy for AH, who was P in this case. Now, the judgment itself is fairly silent as to why there was a change. Perhaps if there's someone from Pennington's on the webinar, you can tell us why. But at the time of the application, West Berkshire District Council was P's Deputy for Property and Affairs. It changed halfway through. Also, a party to this claim was the Office of the Public Guardian. Next slide, please, Emma. And the hearing primarily concerned an application by the Trust Corporation, Pentrust Limited, seeking an order as to whether it could apply for detailed assessment of its costs to the Senior Court's Cost Office. Alternatively, if that was unsuccessful, if it could apply for retrospective approval of its costs that it incurred in carrying out its role as deputy for P. Now, that's not an uncommon position to take because it protects the acting deputy. If they don't get their approval, any costs that have been incurred, they can then receive retrospective approval of. Now, because of the nature of the claim, West Berkshire and the Office of the Public Guardian were neutral to the application because it raised an issue of importance to professional deputies. Next slide, please, Emma. And this was the key issue that you can see at bullet point 1. So at all times when the Trust Corporation was P's deputy, P's liquid assets were less than £16,000. However, that in the context of her whole estate, that was substantially higher, and there's reference in the judgment to it being more towards the £1 million mark due to the value of a property that P resided in. The key issue arose from the actual deputyship order that had been given to Pentrust Limited, which included authorisation to seek detailed assessment, but it didn't refer to the value of P's net assets. Now, that's important because when you get the slides after this talk, when you refer back to Practice Direction 19B, paragraph 12, there is a question mark there as to whether or not the court has to deal with the specific value of P's assets when making such an order. Next slide, please, Emma. The position of the Trust Corporation was that it was entitled to rely on the authorisation given in the deputyship order to seek detailed assessments, and that was despite the value of P's estate. Presumably, the deputyship order gave authorisation for the recovery of costs, but didn't make reference to the specific value of the estate. And as I mentioned earlier, if it was wrong about that, then in any event, it did seek retrospective approval for the costs incurred. Next slide, please, Emma. Now, what was really interesting, if you read the judgment, is that this led to a really interesting discussion around something as minor as a footnote, because as we all know, the Court of Protection rules changed in 2017. In the previous version, there was a footnote in Practice Direction 19B at paragraph 12 that specified that the value of P's estate was excluded, the value of property was excluded when it was lived in by P for the purposes of the net assets calculation. Now, if you look at the revised Court of Protection rules in 2017, that footnote has been removed. So one of the key things for the court to consider in this case was whether or not the terms of the footnote under the previous rules remained relevant despite the fact they weren't in the new practice direction. Next slide, please, Emma. Now, the case ended up in front of Senior Judge Hilda, who, as I suspect we all know, is the senior judge of the Court of Protection. And he found, or she found, that the footnote in the previous Court of Protection rules didn't apply now. Regard was had to the fact that it was in the previous rules, but it was found that if the intention of the draftsman had been to bring that footnote across, it would have been in the new rules. It was something that was so obvious in the previous rules that it would have found its way into the new rules had it been intended to be in there. It was also found that Pentrust Limited had always been authorised by the terms of its existing deputyship order to obtain a senior court cost office assessment of the costs, although the court did recognise the difficulty caused by the removal of the footnote in Practice Direction 19B and the specifics in relation to how the COP rules and the practice directions are drafted. Now, in order to alleviate that, Judge Hilda decided to give guidance on the position moving forward. Next slide, please, Emma. The starting point of the guidance then can be found at paragraph 86 of the judgment, and I've put it for you here. It's where a deputy is appointed in respect of a net estate worth at the time of the appointment less than £16,000, but with authority to seek assessment. The decision maker should make explicit reference to the nature of the estate and paragraph 12 of Practice Direction 19B. Additionally, the deputy should check the terms of the authorisation carefully in receipt of the order. Now, the decision maker referred to is the person making the deputyship order at the court, and it did open up a comment from Judge Hilda that actually this had been common practice in the Court of Protection Registry for some time, although it did understand that on occasion when cases were sent out, it wasn't a procedure that was always followed in some of the district registries. If we can go to the next slide, please, Emma. Judge continued, if the option included assessment, but didn't expressly confirm that such authorisation applied, even where the net estate was worth less than £16,000, the correct option was for the deputy to make a speedy Cop 9 application pursuant to Rule 13.4 for reconsideration. And the court found that such an approach would be of minimal cost to P and would avoid further argument. And when you think about it, it is a proportionate measure. The cost of making what would be a fairly straightforward Cop 9 application seeking clarification or to vary the terms of the deputyship order is not going to cost the earth. It's going to be able to be done within fairly stringently controlled time constraints, and also can be done fairly quickly, and it was deemed proportionate to do so. Next slide, please, Emma. So that being said, what are the takeaways from this case that practitioners need to worry about? Well, it seems to me that there are 4. Firstly, you need to check the terms of the deputyship order extremely carefully when you receive it, and you need to have regard to the value of P's estate when you do so. Where the value is less than £16,000, but authorisation is granted for court cost office assessment, and make sure to check that there is explicit reference to paragraph 12 of Practice Direction 19B. If there is reference, then in theory you should be okay to apply to the Senior Court Cost Office. If there isn't reference, then in any event, to cover yourself for the future, put in your Cop 9 application and get clarification. And it seems to me that the court is likely, based on the guidance given, to grant such an application. I'm not sure yet if there has been any difficulties with professional deputies doing so. There's certainly not been any cases on it. So we'll have to wait and see in some respects what happens. So that's Pentrust Limited. What we're going to come on to now in my whistle-stop tour of deputyship costs is the case of Plk and others Court of Protection costs. Now, this is not a Court of Protection decision, it's a decision of the Senior Court Cost Office itself. You've got the reference there. It's slightly tricky to find on Westlaw and Lexis. The best place to find this decision is Bailey Eye, although there have been materials put together for the purposes of this talk that we can send you, so it's likely you'll get a copy of the decision afterwards anyway. This decision then, Master Whelan, who is a Senior Court Cost Office judge, master, considered the method of assessment of hourly rates by deputies, and in particular, whether they needed to reflect the commercial realities of practice in 2020, rather than rely on the 2010 guideline hourly rates. An interesting question, and it's a question that comes up a lot for those who do other civil cases generally. There is a general feeling that the guideline hourly rates are no longer fit for purpose because they don't reflect the commercial realities of practice now, in particular increases in rent, etc. Helpfully, this case dealt with that issue explicitly in relation to Court of Protection costs. So if we can go on to the next slide, please, Emma. The case itself was 4 conjoined cases, facts of which I'm not going to go into. They were fairly similar. The primary position of all the conjoined deputies, however, was that the court's current approach to costs was incorrect and unjust because it didn't reflect the commercial realities. The tendency was for the court to give deference to the 2010 guideline hourly rates and generally basically force compliance with them. What was asked for was a flexible exercise of the Senior Court's Cost Office discretion, which is more common in civil cases under Rule 44.3 of the CPR. It was further suggested that the guideline hourly rates are a starting point only, not, as appears to have become the custom and practice, the start and finish of the equation. Next slide, please, Emma. Now, there was some interesting guidance and dicta given in the judgment. This is one paragraph that I found particularly interesting. So the failure to review the guideline hourly rates since 2010 constituted an omission that's seriously problematic when the guideline hourly rates are applied. The court recognised the force in this omission that the failure to review the guideline hourly rates threatened the viability of work that was fundamental to the operation of the Court of Protection and the court system generally. Now, this is great because it's there in writing. The court has recognised what practitioners have been saying for years, that the 2010 guideline hourly rates do not reflect the commercial realities of practice. So what did that then mean for these cases? Next slide, please, Emma. Master Whelan then went on to state this. My direction to cost officers conducting COP assessments. So, as I suspect the people watching this will know, often when your cases go into the senior court cost office, it's not usually a master or a cost judge that looks at it in the first instance. It's court cost officers who conduct the assessments and then often get them signed off. So, when they're conducting assessments, cost officers should exercise broad pragmatic flexibility when applying the guideline hourly rates to hourly rates claimed by deputies. If the hourly rates claimed fall within around 120% of the guideline hourly rates, then the direction is that they should be regarded as being prima facie reasonable. And then it follows then that rates claimed above this level will be correspondingly unreasonable. Now, in some respects fairly wishy-washy. What does this look like in practice? Well, you don't all need to sit there with your calculators out. Helpfully, this box was printed on the face of the judgment, which gives the guideline hourly rates with the uplift envisaged by the court. So I'm not going to take you through the maths, but if you do the maths on the original guideline hourly rates, you can see that this has increased the hourly rates by around 20%. So these are now, in my view, moving forward, the hourly rates that should be being claimed by professional deputies. If we can go to the next slide, please, Emma. Now, the problem with the senior court cost office and the fact that it's a decision that was made by a master means that it's not always considered as persuasive. Now, the approach was adopted in a practice note by the senior cost judge, Gordon Sacker. Again, we can provide you with a copy of that practice note after the talk, who reiterated that the judgment was limited to the years 2018 and following, and that it would only be of relevance where rates in excess of the guideline hourly rates have been claimed in the bill, because the cost office doesn't have discretion to allow higher hourly rates that have been claimed. If you put your bill in and note the hourly rates that are claimed on there, the court cost office will consider those hourly rates, but it won't grant you anything higher than what you've claimed. If we can go to the next slide, please, Emma. Further guidance was given that deputies can't withdraw or amend a detailed bill without the consent of the client or by court order. So, i.e., it's effectively a warning saying if you've submitted bills already, we don't want a flood of applications withdrawing bills or amending them to try and get higher hourly rates. It's just practice that you should do moving forward. Of course, deputies are entitled to informal reconsideration. But in reality, as the court has said, it should be noted that any requests for reconsideration designed to recover rates higher than those claimed in the bill are unlikely to be successful. And next slide, please, Emma. More helpfully, cost officers will continue to have regard to the deputy's terms and conditions of business and general correspondence, etc., as was always the case. Next slide, please, Emma. Following that, the Office of the Public Guardian clearly got slightly concerned that it was also going to receive a flood of correspondence from solicitors, because they then put a policy statement out. Again, a copy of this can be provided after the event. That says clearly the Office of the Public Guardian recognises that the assessment of solicitors' fees is a matter for the SCCO. However, the judgment will inevitably result in an increase in fees claimed against the estate of protected parties. That's fairly obvious. Next slide, please, Emma. And then to cover itself, of course, the Office of the Public Guardian does not expect to be notified of any increases in costs that are in accordance with the principles set out in the Plk judgment, but it does continue to require notification of increases in costs that fall outside of these principles. Now, on a practical point, that's extremely helpful, because it obviously saves deputies a step. Next slide, please, Emma. So just like with Pentrust, what are the takeaways from the Plk case? Well, firstly, professional deputies can, in theory, increase their costs moving forward by 20% without needing to notify the Office of the Public Guardian. Something that I've thought about since we first gave this presentation is what was actually mentioned in the note given by the senior cost judge, which is that regard is still going to be had to terms and conditions of business, etc. And it seems to me that actually, in order to fully protect yourself, if you're acting or a solicitor acting as a professional deputy, you probably need to be amending client care letters and things to make sure that the revised hourly rates are contained within those client care letters. Now, that was all I was going to talk about in terms of Pentrust and PLK. I'm going to hand back to Emma now, who's going to talk you through the decision of Re, ACC and others. So thank you for listening.
Thank you, Matt, for that really clear and really concise introduction to those two cases, which are clearly of great importance to practitioners. I thought that that was really helpful. Let's move on now to something a little bit different. If I can get the slides to work, there we go. ACC and others, and this was a case which concerned whether and in what circumstances a deputy can recover from P's assets costs which have been or are likely to be incurred in legal proceedings. This is another case from Her Honour Judge Hilda, the Senior Judge of the Court of Protection, and it was a case that came out in February of this year, which I know for many of us seems like a very long time ago now in all that's happened in between. But clearly Her Honour Judge Hilda has had a very, very busy year, as I hope all of you have as well. When I speak about this case, you're going to hear me talk about three individuals, because this case concerned three individuals: ACC, JDJ, and HPP. And these three individuals all had one thing in common, and that was that they each had a deputy for property and financial affairs who was in some way a part of Owen Mitchell, either Owen Mitchell LLP or Owen Mitchell Trust Corporation Limited. That was the link that tied all of these three individuals together. In respect of ACC, the legal proceedings that had been or were likely to be ongoing concerned an education healthcare appeal, an appeal in the first tier tribunal, SEND tribunal. So for those of you that have at any stage had any experience of education law, the first tier tribunal, SEND tribunal, will be very familiar to you. JDJ, similarly, also concerned an EHCP appeal, Education Healthcare Plan appeal. HPP, so the third individual that this case concerned, the litigation contemplated was slightly different there, because that concerned a claim for damages for personal injury. Don't worry for that whistle-stop tour through the individuals. I'm going to talk you through the parties in a little bit more detail in a couple of slides on, so bear with me. In addition to the individuals that I've mentioned there, so those individuals, they were represented by the official solicitor due to, I think, quite an obvious potential conflict of interest in this case, given that the issues that needed to be determined. The public guardian was also a party in these proceedings due to the matters of principle that required determination. And in effect, certainly in respect of ACC and JCJ, what was being asked was that the deputies were seeking retrospective permission for authorisation of legal fee expenditure. So that's very much at the heart of this case. Now, if we look at the standard wording of a deputy appointment, they usually say something like this: the court confers general authority on the deputy to take possession or control of the property and affairs of P, and to exercise the same management, powers of management and investment, including letting property, as she has beneficial owner, subject to the terms and conditions set out in this order. That wording that we see there on the slide is consistent with the standard wording for property and affairs deputyship template. It's consistent with that template. Now, the orders didn't contain, in this case, any express provision, either granting or excluding authority to instruct solicitors or to conduct any kind of proceedings on behalf of P. Now, indeed, the standard template that I was speaking about just a moment ago, that doesn't include provision expressly addressing Section 18(1)K of the Mental Capacity Act, which, as I'm sure you will all know, is the section that concerns the conducting of legal proceedings in P's name or on P's behalf. I mentioned earlier that I would spend a little bit more time talking you through some of the parties in this case, and we're going to start with ACC. ACC had sustained a serious injury at the age of 4 and had received a substantial award in damages. The award was £3 million plus periodical payments of approximately £180,000 a year. So for any of you that have had any experience in doing PI work, you will know that is a significant sum, and significant injuries were sustained in respect of ACC. In this case, the local authority had decided to end its support to ACC under what is known as an education healthcare plan. ACC at the time of this judgment coming out was 20 years of age, but at the time the decision was made by the local authority to end its support to ACC under an EHCP, ACC was 18 years of age. The deputy wanted to challenge that decision of the local authority and sought advice from Erwin Mitchell, who, as many of you will know, have expertise in the field of education law. Effectively, what Erwin Mitchell was offering for the purposes of ACC was a one-stop shop. So the deputy issued an application for authorisation for this and to pursue the appeal. The appeal was issued and proceedings were successfully concluded. So the application before the Court of Protection was therefore limited to retrospective authorisation of costs that had already been incurred. So that's ACC. JDJ was in a not dissimilar situation. So JDJ had sustained a brain injury due to clinical negligence at birth. And at the time that this judgment came out, JDJ was 17 years of age. JDJ's family had identified a special educational placement for JDJ to attend, but the local authority had decided that a different mainstream college could meet his needs. No doubt it was a college that was perhaps less expensive than the placement that JDJ's family preferred. The deputy issued an application for authorisation for advice and to pursue an appeal. Again, it would be an appeal in the first tier tribunal, the Special Educational Needs and Disability Tribunal. 10 days later, the appeal was issued. Now, who gave the instructions to issue the appeal was a matter which I think at this particular hearing in front of Her Honour Judge Hilda caused some concern, because it wasn't clear who Erwin Mitchell had actually been instructed by, whether it was the parents or the deputy. And the judge, in her judgment, made some quite scathing remarks in relation to that particular issue, because it seemed nobody was able to answer that question. In terms of the appeal to the first tier tribunal, so concerning the education healthcare plan, the appeal was lost, but some modifications to the plan were achieved, modifications to sections B and section F, so the description of the child's needs and the provision required to meet that need. But in terms of the issue of placement, the appeal was unsuccessful. So that takes us through JDJ. Let's move on then to talk about HPP, the third individual that this case concerned. HPP was an adult male who had sustained significant injuries in an accident. At the time that this case was being determined, he was 50 years of age, and he had been a cyclist who'd been struck by a lorry, sustaining very significant injuries. In terms of the personal injury claim then that was being pursued, liability had been admitted, but quantum of damages had not, and that required determination. During the course of this personal injury litigation, HPP had 3 different litigation friends over the course of the proceedings, which is, certainly from my experience, somewhat unusual. He had entered into, or on his behalf, CFAs had been entered into with significant uplifts, and this was even after liability had been admitted, again, perhaps slightly unusual. The deputy sought a detailed assessment of costs by the Senior Costs Office in that case. and was also asking the court to determine whether or not the litigation friend could charge for their services. So was seeking the court's authority to charge as acting as litigation friend for HPP. Now, David Rees QC, acting for Owen Mitchell, argued, and this was the position adopted, that authorisation should include unexceptional, non-contentious legal tasks such as conveyancing, tax returns, leasing and contract drafting, and obtaining legal advice, incurring costs short of the conduct of litigation. It was deemed that that should be the point at which authority should be granted, but not beyond that. And if urgent action is required, a deputy should be able to issue proceedings without specific advance authorisation. And it was the position adopted by Owen Mitchell and by David Rees QC, acting on behalf of Owen Mitchell, that the Court of Protection should consider retrospective applications made sympathetically. The official solicitor's position was a little different, but aligned on some issues. The official solicitor accepted that obtaining legal advice was a best interest decision. Obtaining advice will sometimes be within a deputy's general authority, and this may include instructing their own firm. And the standard wording does not include authority to litigate, although could include some modest work. The line between advice and conducting litigation should be after the letter of response, but before issue. And the reason that that particular stance was adopted by the official solicitor was that it was her view that once a letter of response has been received, then the Court of Protection would be in a better position to determine things like the prospects of success. They would have a clearer picture at that point of what both parties' cases are going to be going forward, and so can perhaps form a more informed view on whether authority to conduct litigation beyond that point should be granted. The official solicitor also adopted the view that in urgent situations, a deputy should be able to achieve retrospective authorisation. So it didn't go as far as to necessarily say that such application should be dealt with sympathetically, but nevertheless said that that you should be able to achieve retrospective authorisation. The official solicitor very much opposed the position of a deputy charging to act as litigation friend to HPP, so charging a fee. As you will all know, the official solicitor, of course, acts as litigation friend to many without cost, where no other person could step in to act in that role, in that capacity. And what was the position taken by the public guardian? Well, the public guardian sought further clarity in the specification of the deputy's powers, stating it would be greatly assisted by this. And they sought guidance from the Court of Protection on the issues raised. The office of the public guardian was very much neutral in terms of the facts, and perhaps played a slightly lesser role in the hearing itself. But this slide sets out the position that was adopted by them. It's noted its guidance provided to deputies to consider the instruction of alternative lawyers rather than an associated law firm, and made a recommendation that this could include obtaining 3 other quotes from different law firms. The judgment itself is quite lengthy, but I would encourage you all to read it if you haven't had an opportunity to do so far. What I found very helpful as I went through the judgment was actually the appendix. So at the very end of the judgment, Her Honour Judge Hilda has very helpfully included an appendix, which is a summary of her conclusions. So if you're reading this judgment for the first time, you might actually want to start at the end. Have a look at the appendix. It's only 2 pages long, and it really helpfully summarises all of the issues and her decisions in relation to the key issues in this particular case. And it really is very helpful in terms of accessing the judgment as a whole, not least of all, because in addition to summarising her conclusions, she cross-references throughout the paragraphs of her judgment, which effectively state what she is saying there in the appendix. So it's very, very helpful. It's in essence looking at 18(1)(k), so the power that deputies have to conduct litigation in P's name, is one of the examples of a decision which may be made under section 16. It was accepted in the judgment that retrospective authorisation is possible under section 16 by way of analogy with section 23(3)(d) for attorneys. The general authority to act should be interpreted, the judgment says, in accordance with ordinary language, and that's paragraph 47 of the judgment. The standard template order for deputyship includes specific provisions in respect of major transactions, but the judgment goes on to say it would be impractical to include specific provision for every smaller day-to-day transaction. So the court adopts the approach of granting general authority. In terms of assisting and what is meant by general authority, it would include things such as conveyancing, dealing with leases and tenancy agreements, dealing with employment contracts if P was a business owner, advice on contemplating a tax return, advice on liabilities under a tenancy agreement, employment contracts for carers. Those are the types of things that could be incorporated under a general authority which exists. But the authority to conduct litigation specifically needs to be granted. It isn't covered by the general authority as referred to there in the previous slide. So that's a really important takeaway from this judgment. And it starts, the judge's commentary on this starts at paragraph 51 onwards of the judgment. You may be asking yourself, looking at this, well, what about if the litigation contemplated is litigation in the Court of Protection itself? Well, what then? Well, here, because of course it would seem rather absurd, wouldn't it, if you had to seek permission to conduct litigation in the Court of Protection by making an application to the Court of Protection for such authority. Well, the position there is that if the action contemplated in the Court of Protection involves property and financial affairs, no authorisation is required. If, though, it involves issues of welfare, then care needs to be taken before a property and affairs deputy makes such an application. Significantly, though, what the court went on to say is that there is a requirement of the deputy to bring to the court's attention the need for welfare proceedings if a deputy becomes, a property and financial affairs deputy becomes aware that such proceedings may become necessary. So you are encouraged in those circumstances to bring the matter to the court's attention. Judgment went on to say that the authority to act on behalf of P encompasses such ordinary legal tasks short of taking proceedings. And the judge held that she accepted the official solicitor's position here, that it should be up to receiving a letter of response. The reasons for that being, as I've already indicated, at that point the court is going to be in a more informed position to make a decision on whether or not to grant authority to conduct litigation. Costs for such activities should be covered by fixed fees or assessed by the SCCO to ensure the scope of costs exposure is limited. And when the court considers an application for authority to conduct litigation, it's going to consider whether or not there should be limits placed on such authority. Are there concerns, for example, about the merits of an action? Would it be beneficial for the Court of Protection to see advice from counsel or solicitor? I'd say almost definitely it's going to be hugely desirable. Will the court limit authority up to a specific phase in litigation? They often do. Or will the Court of Protection put a particular limit on the costs going forward? These are all matters to consider. In terms of education healthcare plan challenges, it was determined that authority should be sought in advance of appeals, both against continuing healthcare funding and challenges to education healthcare plans. But the court should be asked to determine the matters expeditiously. The court accepted that there are going to be some circumstances where an application can't be obtained in advance because urgent action needs to be taken. And in those circumstances, a retrospective application should be considered. Significantly, the court did not adopt the view advocated for by Owen Mitchell that there should be, those applications should be viewed sympathetically. The court was very cautious to say that no presumption, there is no presumption that such an application will be granted. Each application is going to be considered very much on its own merits. And that's effectively set out in the next slide. Each case is going to turn on its own facts and merits, and the court cannot be relied upon to treat such matters sympathetically. The court gave specific guidance as to the circumstances where the deputy seeks to instruct his own firm, seeking either specific authorisation for the same in the application or following strict rules before such appointment. Now, obviously, there are going to be certain circumstances where it will be in P's best interests to for a deputy to instruct their own firm, because perhaps their firm has to be plenty of issues there to weigh into the balance. But in terms of guidance, what the court said was that a deputy may seek prior authority before instructing their own firm, but they are required to seek 3 quotations from providers, which includes their own firm, in a manner that's proportionate to the issues to be determined. And they must seek prior authority if anticipated costs are going to exceed £2,000 plus VAT. And they must set out legal fees incurred in the account to the public guardian and append any notes of the decision-making process. So if a firm is going to instruct their own solicitors to carry out a piece of work on behalf of P, that's fine, but the firm will need to follow that guidance and also be able to justify their decision-making to the public guardian at the relevant time. Now, the Court of Protection was very concerned as to the idea that P should ever need to pay a person to act as their litigation friend, as was being requested in HPP. But no determination was actually necessary on this issue, because a significant concession was made by the official solicitor to act free of charge in certain appropriate cases where her usual criteria are met. So it wasn't a matter that actually had to be specifically decided by the court, but nevertheless was something that Her Honour Judge Hilda did make comment on. So what happened in each individual case? Well, in respect of ACC, retrospective authorisation for the costs to the challenge of the HCP were granted. In JDJ, it was said that the deputy must be abundantly clear as to who is giving the instructions, him or his family. So as I say, there was that rather scathing remark made by Her Honour Judge Hilda in respect of JDJ and who was giving instructions. The Court of Protection noted there was no good reason why authority had not been sought in advance. Weight was, however, given to the advice of independent counsel in that case, JDJ, as to the merits of the appeal. I think from memory, counsel had put prospects of success as something like 75%. So solicitors were understandably encouraged by that. Retrospective authorisation was granted in the Court of Protection, but as I've alluded to, the judge quite clearly said that nothing in this decision should encourage property and affairs deputies to consider that there will on other occasions be similarly positive determinations. Each application will be determined very much on its own merits and on its own facts. So in HPP, in light of the official solicitor's offer, the deputy conceded that she would act free of charge, and the Court of Protection noted that the official solicitor's concerns that another litigation friend would possibly have been able to obtain better terms than the 20% CFA uplift. This was, of course, the case where in the personal injury claim liability had been admitted. An authorisation for fees was granted, but not without some reluctance, paragraph 63.7. ladies and gentlemen, that concludes my section of the talk. Because I've been so busy turning slides, I haven't had much of an opportunity to assess the question situation. So I am going to stop sharing my screen now and see if we can field a few questions in the last 15 minutes. And if there aren't any, then you can all have a very early lunch break. So let me see what we can do here. There we go.
Bit of an interesting update has come in from one of the guys at Pennington's. The reason, although it's not covered in the judgment, for the change from Pennington's to the local authority was because it wasn't in the best, they didn't consider it in the best interests for professional deputies to continue to act as ongoing work was at a level that a local authority could manage. So that makes complete sense and seems completely fine. Comment has come in from Neil Russell. Thank you for your comment, Neil. Just drawing our attention to, there's a recent, I think it was a Chancery Division case, but I'm not 100% sure, a case called Cohen and Fine, which it wasn't in the context of court protection proceedings as far as I'm aware, but it did give some guidance to the fact that the court should potentially look at giving a 35% uplift to hourly rates claims. I actually, in the background, found a relevant extract of the judgment. It's paragraph 31. If anyone is interested in taking a look at that, and paragraph, it doesn't say, but there we are. There's a great little section on what I saw the other day on, I think it's the civil litigation brief, one maintained by Gordon Excel. So that's really helpful if anyone wants to have a look at that.
Yeah, I'm a big fan of Gordon Excel's webpage. It's very, very helpful. I've had a couple of questions in terms of ACC. Thank you to those that have asked questions. Re-ACC, presumably a property and financials affair deputy can, under general deputyship order, agree to pay the costs of a health check of an EHCP, i.e. advice from specialist education solicitor. That's a really interesting question, not something that was specifically addressed in the judgment, but I'd say it certainly stopped short of the issuing of proceedings. So Matthew, I don't know if you have a different view, but I suspect that a health check of an EHCP would be covered under a general deputyship order. That seems to align with the judgment. Yeah.
There's a similar question actually. Well, it's more of a comment. We applied to the COP for an EHC appeal, submitted an application in April with a deadline of the 30th of July. We only received an order back 2 weeks ago. Deputy had to make a best interest decision to proceed without the authority of the COP as P was starting school in September. I don't know about you, Emma, but I suppose that's kind of an urgency where you'd hope you would get retrospective approval, because otherwise you've got reissues come September.
Yeah, absolutely. And particularly when you've made the application so promptly yourself, you would hope that, I know that Judge Hilda couldn't go as far in her judgment, didn't go as far in her judgment to say that such applications should be dealt with sympathetically. But on the facts of that case, it seems that, yes, you would certainly hope that retrospective authority there would be granted. Another case, again, another question, re-ACC. In a situation where a deputy has instructed their own firm on a contentious matter to provide initial advice before the re-ACC decision, is the deputy required to obtain estimates for future costs from other firms when seeking authorization to issue? I suspect that the answer there would be yes, because I think at that point, when you're contemplating issuing, that's that's going at that additional step, isn't it, in terms of conducting litigation. And I think you would at that point be required to provide estimates from other firms going forward, notwithstanding the fact that you have got your initial advice from another. I know it's not exactly desirable, but I would certainly be wanting to err on the side of caution there. Again, uncharted territory, but Matt, what would you say in a case like that?
Sorry, Emma, I was looking through the chat box.
No, that's fine. I mean, so the question is that where a deputy has instructed their own firm on a contentious matter to provide initial advice before the re-ACC decision, is the deputy then required to obtain estimates for future costs from other firms when seeking authorisation to issue? I think the answer would be yes, especially now that the case has come out, the decision has come out, and you're going a stage further in terms of actually seeking authorisation to issue. I think you probably would require those 3 quotes from different firms, including one of your own, to carry that next stage forward. That would be my feeling, my gut feeling. But as I say, it's slightly uncharted water. And we've lost Matthew, so I'm going to assume that he'd agree with me. I suspect what's happened. Oh no, he's back. I was saying, Matt, I suspect what had happened is you've been urgently summoned.
No, so interestingly, an email has literally, I've just seen, gone in to try and vacate it. We've got real issues in South Wales with PlusNet internet, so I'm tethered to my phone at the moment, and my data just ran out.
Oh dear, put another pound in the meter.
What it does mean is that I've lost all the questions in the Q&A, so you might have to read them.
No, I think it was because in terms of the questions, we've gone through them all, which is pretty good. I'm catching up on the chat as well to see.
Someone has just asked for the address of the civil litigation brief. So
yeah,
it's
we can paste that in.
Yeah, it's www.civillitigationbrief.com.
Yeah, definitely worth a read. So there we are. I think we've certainly caught up. Oh no, there's another Q&A question. Given the litigation friend issue wasn't determined in this case, what's the best approach for when nobody else is willing or able to act other than ourselves, when also a deputy? OS asks to act but take months, so not in P's best interests. I mean, I think the issue is it's whether or not you're going to charge, I think, is one of the key takeaways from this case. If you're going to charge for your time as acting as a litigation friend, then that could prove problematic. The court was clearly in ACC quite concerned about that. If it's a case, especially if you've got a situation, for example, where limitation might expire or something of that ilk, and you need to get on with something quite urgently, and you're concerned that the OS isn't going to respond in time, then you may well have no other choice. Yes, I think beyond that, that's a tricky one. And as I say, I think that there's no particular decision on that, because it was taken out of Hannah Judge Tilder's hands by the OS's remarks, but it is clearly something that the court may take a dim view of if you're charging to act as litigation friend in circumstances where the OS could step in, especially if limitation is not an issue. Come on, Matt.
I suppose what you're going to need to do is put the usual kind of standard wording in to invite the OS in, but have something along the lines of, well, actually what we did in my one today, have something in there in the interim saying that as deputy you will act as litigation friend until the appointment of the official solicitor. And I accept that it does take an awful long time. But in reality, if you're going to act in your client's best interests and you've got an urgent limitation issue, it may be a case of having to suck it and see, unfortunately. I mean, I suppose it may be a circumstance when it's going to depend on the urgency, isn't it? Because it may be that they're the kind of costs you can get retrospective approval from if you can show that you're the only person able to act, and that for whatever reason the need to issue was in P's best interests. But it's not an ideal situation at all.
No, but I think if time is on your side, then I would suspect that OS should be first port of call, really. But if it's not, then as you say, Matt, you might not have any other choice.
There's another Sorry, go on.
No, thank you everybody for your questions. It always makes this part of the talk far more interesting. And we learn just as much from the questions that you're asking us as we hope you learn from our answers. Another question, again, ACC. In terms of ACC and needing a litigation friend for clients with a PI claim, have you noticed a trend from the court regarding whether they are appointing the deputy or the OS? I've made 2 applications recently, and on one, the court appointed deputy. On the other, they've asked us to see if the OS will act. I'm wondering if there is a standard approach from the court. I'm not aware of there being a standard approach from the court at the moment. I mean, ACC came out in February, so it might just be that it's taking a bit of time for some sort of standard approach to be adopted. So I think the short answer to that question is I'm not noticing a particular trend one way or the other. So I'm sorry that I can't shed more light on that.
No, I'm not convinced there's a particular trend. I think it's much more helpful to have the OS in, but reality is they are the litigation friend of last resort. So again, it might be a case of having to just put up with it.
Okay, another particular question that relates to ACC and individual SEND cases. Does the ACC case now require deputies to obtain 3 quotes on each individual SEN case they are looking to issue, rather than seeking broad estimates generally from the firms as to their general cost estimates in such appeals? This is a tricky one, isn't it? Because a lot of firms will offer in SEND work potentially a fixed cost to cover everything, and that could be, I suppose, tricky if you're in a situation where you might feel quite confident that the case is going to settle, and you might not have to go all the way to a final hearing. So it might be trickier to get the quotes in those sorts of cases than you anticipate. But I think if you are confident that you're going to be issuing your appeal in the SEND tribunal, I think it would require you to obtain those 3 quotations. So 1 from your own firm and 2 from another.
I think, Emma, just because I haven't had confirmation that my hearing has come out yet and it does start at 12, I'm going to disappear. Yeah. So I'm going to leave you to field the rest of the questions, but thank you everyone for coming. Oh, no, wait. No, yeah, it is still going ahead. I better run. Thank you everyone for attending. And hopefully I will speak to some of you soon, but Emma, I'll leave you to finish off.
Lovely. Thank you very much. Another tricky one here, re-ACC. Deputy for Property and Affairs is also able to act as litigation friend by court order. Instructed own firm for initial advice on litigation, re-claim, prior to ACC, and now costs have exceeded 2,000 post-ACC. Do we need to make an application for costs retrospectively now? That's a really interesting question, and it's a tricky one, in as much as what the judge said in the ACC is that the deputy must seek prior authorisation from the court if the anticipated costs exceed £2,000 plus VAT. So I'm afraid I'm not immediately sure on the answer to that question, and that's going to be one that I will have to go away and have a think about, because it is tricky. I'm always one to err on the side of caution, but I know that different barristers can take very different approaches to these cases. Thank you all ever so much for your really, really interesting questions that have come in the last few minutes, thick and fast. We're really, really grateful to you all, not only for your questions, but for attending this afternoon and this morning. We hope that it's been useful to you. It's been great to have you all here. And we will look forward to welcoming you to another one of these talks in the not so distant future. As has already been said in the chat, we will send these slides to you. And I think we have some handouts as well that might be quite helpful. And any questions that we haven't answered, we will do our best to answer this afternoon as we go away and have a very hard think about some of the questions you've raised. Thank you ever so much for your time, and good afternoon, everybody.